President of Law Society, CM Chen, distinguished guests, ladies and gentlemen. Good morning. It's my honor to join you all at this very special event organized by the In-House Lawyers Committee of the Law Society at the Hong Kong Convention and Exhibition Center. And as some of you may recall from my sharing at the conference last year, I found this conference particularly relevant to myself, given the in-house nature of my role as the Secretary for Justice. My department, the Department of Justice, is the largest employer of in-house counsel in Hong Kong. And having been in this position for slightly more than a year, I'm becoming increasingly convinced that to excel as an in-house lawyer, knowing the legal options is just the very first step. And very often, we have to take one step further to put the legal technicalities aside for a moment, step into the shoes of our lay clients, and look at things from this perspective, so as to come up with the most suitable solution, and more importantly, to be able to convince them that it's indeed the most suitable solution. This job is by no means easy, and here I would like to salute to all in-house lawyers. You all have been doing a wonderful job. Now, the theme for this year is in-house lawyers being not only an in-house connector, but also a super connector. You, as in-house lawyers, are known for your role as in-house connectors who serve to enhance corporate governance and compliance, avoid disputes, and handle disputes if they do arise. Yet the scope of influence does not stop there. As I emphasized last year, you are indispensable members not only of the Hong Kong legal community, but also Hong Kong as a whole. You are in fact a super connector, helping your employers decide whether to move or expand their business to Hong Kong. You may also take part in deciding where a business should be headquartered, what should be the governing law of the contracts that your employees are negotiating, where and how any dispute arising out of this contract should be resolved, and if necessary, which legal practitioners should be engaged. My goal today is to show you how you may capitalize on the unique advantages of Hong Kong when performing your role not only as in-house connector, but also super connectors. Hong Kong is, of course, an international legal service and dispute resolution hub, and we have a diverse pool of legal talents. But a very unique, and perhaps the most unique advantage enjoyed by Hong Kong is the substantial opportunities offered by the principle of one country, two systems. At the 25th anniversary of the establishment of the Hong Kong Special Administrative Region last year, President Xi Jinping made crystal clear that the principle of one country, two systems is a long-term policy that must be adhered to and will certainly go beyond 2047. This means that Hong Kong will remain as the only common law jurisdiction in our country, China, bring along with its fundamental features such as the rule of law and the independence of the judiciary. The National 14th Five-Year Plan, also mentioned by President Xi in his speech, explicitly supports Hong Kong's development into a center for international legal and dispute resolution service in the Asia-Pacific region. This, coupled with other national development policy, such as the Guangdong, Hong Kong, Macau Greater Bay Area Initiative and the Belt and Road Initiative, makes Hong Kong truly a place full of opportunities for the business and legal communities. Now, many of you are serving clients that have overseas presence or business dealings with overseas partners and customers. Dispute resolution across jurisdiction is very likely a day-to-day business to a number of you. On this note, enhancement of cross-border cooperation and collaboration between different legal systems, particularly the one in the mainland and in Hong Kong, has been a major priority of DOJ's work in recent years. And in this regard, I would like to take this opportunity to highlight a few initiatives on cross-border matters that may be of particular relevance to you. First, as many of you may already know, Hong Kong has entered into various legal assistance arrangements with the mainland on a couple of matters. Major ones include the following four areas. First, procedural arrangements such as service of judicial documents. Second, reciprocal enforcement and recognition of judgment, what we commonly refer to as the REJ. Third, insolvency matters, and fourth, arbitration. Now, the arrangement for mutual service judicial documents in civil and commercial proceedings between the mainland and Hong Kong court is the first in time among the legal assistance arrangement. To accommodate the increasingly close social and economic ties between the two places, the Department of Justice is, together with the judiciary, actively pursuing discussion with the Supreme People's Court with a view to increasing possible modes of service and enhancing efficiency. We hope that our discussion will result in an improved arrangement which will make service of judicial documents between the two places more convenient and efficient. In relation to the REJ, I'm pleased to say that the mainland judgment in civil and commercial matters, reciprocal enforcement ordinance, was enacted in 2022. Compared to the existing regime under the choice of court arrangement, the new mechanism covers a much diverse range of civil and commercial matters, including, for instance, intellectual property rights. And what's more, it covers both money and non-monetary awards. This would establish Hong Kong as the only jurisdiction with just an extensive REJ coverage with the mainland. Another notable improvement the ordinance will bring to the existing regime is that it will remove the requirement of exclusive jurisdiction clause as a precondition for cross-border recognition and enforcement of judgment. The subsidiary legislation under the REJ ordinance is expected to be ready by early next year. With the subsidiary legislation on the Hong Kong side and the judicial interpretation on the mainland in place, the REJ ordinance will then take full effect. Meanwhile, I'm sure that as in-house lawyers, many of you may need to advise your employer on the legal options available when a business partner or a customer has difficulty keeping up with payment or delivery or has simply been driven out of business. If the business partner or customer is based in the mainland, the record of meeting signed by the Department of Justice in May 2021 with the mainland may be of particular interest to you. Under the groundbreaking record of meeting, a pilot scheme is established to allow Hong Kong liquidators and provisional liquidators to apply to mainland courts in 3 cities, namely Shanghai, Xiamen, and Shenzhen, for the recognition of insolvency and debt restructuring proceedings in Hong Kong. This means that assistance may be granted in relation to, for example, the taking over of the debtor's property and investigation into the financial position of the debtor, who is subject to insolvency and similar proceedings. There's no question that this record meeting will provide better protection to safeguard the interests of creditors. And since its inception in mid-2021, there have been a couple of cases where Hong Kong liquidators will recognize and grant assistance in Shenzhen and Shanghai. I'm sure there will be more to come. And given the obvious benefit brought about by the pilot scheme and the fact that the court in both places are becoming increasingly familiar with this type of cases, I sincerely hope that in the near future, it would be expanded to other cities in the mainland. The last is the bundle of arrangement concerning arbitration, which provide a comprehensive regime for recognition and enforcement of arbitral awards between the two jurisdictions. In fact, under one of the arrangement, Hong Kong parties are the first and only one which could be granted interim measures by mainland courts outside the mainland. Further, the legislative amendments and amendment to the arbitration regime in Hong Kong last year, to the arbitration regime in Hong Kong, namely the outcome-related fee structure for arbitration, and secondly, the third-party funding for arbitration. And because of these arrangements, the multi-funding options are now available in Hong Kong for the conduct of arbitral proceedings, and thus will in turn enhance access to justice and improve the competitiveness of Hong Kong's arbitration services. Another highlight which probably has come to the attention of many of you is the implementation of the United Nations Convention on Contracts for the International Sale of Goods since 1st of December last year. The CISG has been described as the most successful substantive uniform commercial law treaty. Applying the convention to the Hong Kong SAR will allow for a uniform sales law to govern the bulk of Hong Kong's business international sales transactions, enable business to trade with their overseas counterparts on a fair and level playing field by using a sales law which is familiar to the parties. This would further enhance Hong Kong legal infrastructure for international sale of goods and bolster its role as an international hub for trade and dispute resolution. While we endeavor to improve the legal infrastructure of Hong Kong, we know that such legal infrastructure can only be put into best use with complementary administrative measures. An example would be the pilot scheme on facilitation for persons participating in arbitral proceedings in Hong Kong. Now, since the scheme came into effect, arbitrators, expert and factual witnesses, counsel and parties arbitration no longer need any employment visa. And very recently, this scheme had been extended to include those from the mainland, Macau, and Taiwan, and has been renewed up to February 2025. And with this measure in place, Hong Kong has become a much more attractive and convenient seat for arbitration. If your company seeks to grab the opportunities in the GBA, you may also wish to know more about our initiative, 港資港法 and 港資港仲裁. Under this initiative, Hong Kong invested enterprises are allowed to adopt Hong Kong law and choose Hong Kong as the seat of arbitration in their contracts. This initiative is currently effective in specific trial areas, Qianhai in Shenzhen, and 3 trade zones in the mainland, where exceptional rules apply to allow Hong Kong law or Hong Kong as a seat of arbitration to be chosen, even if these contracts do not have what we call foreign-related elements. Now, this initiative has created more options for Hong Kong invested companies and business enterprises exploring their opportunities. We are actively seeking to further liberalize the measures to cover all 9 mainland cities in the Greater Bay Area. Ladies and gentlemen, as in-house lawyers, you are encouraged to capitalize on Hong Kong's unique advantage, namely a world-renowned common law system with legal infrastructure constantly being improved to facilitate cross-border deals and activities. With the support of the Central People's Government, the DOJ will continue to work hard to explore and take forward initiatives in different areas to facilitate your role not only as in-house connector, but also super connectors, so as to fully grasp the opportunities under the National 14th Five-Year Plan. Last but not the least, my thanks go to Law Society for organizing this very special event and bringing together all these legal talents. I wish you all a very successful, interesting, and fruitful discussion in the conference. Thank you very much again, and I'll see you at lunch. Thank you.